USCCA spokesperson Tom Grieve releases a video critiquing AOR. Do we have anything to say about it? You bet we do. Stay tuned. This is attorney Andy Marcantel and attorney Marc J. Victor of the Attorneys for Freedom here today to talk about a video that just dropped like 2 hours ago. How you doing today, Marc?
This is so fun. I wish we'd do more of these videos.
Okay, you're having fun with it.
I'm having a great time.
Just to paint the picture of my day, I've been in court all day long, very, very busy day in court and at the law firm, and I'm on my way to a pre-sentence interview on a self-defense gun case when I hear Marc from down the hall, Andy, come in the office. You got to see this video, man.
You're going to love this. Yeah, you're going to love it.
And I did love it, and that's what we're going to talk about today.
So fun, man. 800,000 members USCCA has, and they are worried about the Attorneys on Retainer program, and they should be.
They should be.
Yeah, it's clear that they made this video just to try to deal with the avalanche of people leaving USCCA and joining the Attorneys on Retainer program.
That's right. And if you want to see any evidence of this, go and check out our comment sections on our videos, and you'll see a lot of people saying that I called to cancel my USCCA membership and sign up with AOR, and the representative tried to claw me back in, essentially, and tell me, no, don't leave, just stay with us. We promise everything is okay. I think people are starting to wise up about these insurance-backed programs.
Yeah, this is great. Look, there are pros and cons to each program, but the more information that gets out to the market, that's accurate information, is going to be good. And so this is good for Attorneys on Retainer because we feel very confident we have the best program. And so this is all good news. We're super happy that he made this video, and we're excited to respond to it.
Yeah, that's a very good point. I think we should start by kind of talking about something he said at the end of the video, which I think would be a good way to lead our video, frankly, which is that we really all are on the same team in this community as long as we are acting in good faith. I think that's a very good point. Now, while more information is better and while getting all this information out to the public is really important, as long as people are acting in good faith, even if we feel that it's misguided, it's an important point to keep in mind. We're not looking to vilify anybody. We're not looking to bash on anybody.
That's right. And we've said before, we have no reason to think that Tom's not a good lawyer or isn't acting in good faith. Look, if he was here, I would probably try to sprinkle some holy water on him to try to
this is going to be a prosecutor.
Yes, man. I absolve him from his prior sins of being a prosecutor. Who knows how many people he prosecuted, maybe for gun cases, for victimless crimes, or all of the other horrible things that some prosecutors, maybe he didn't do any of that stuff. I don't know. But he's a defense attorney now, maybe for the last 10 years or so is what I got from that video. So he's a brother defense attorney. I think we treat him with the respect and kindness that he deserves as a fellow criminal defense lawyer.
No question.
Yeah.
So let's start going through his points here. Let's talk about point number one.
Who decides if you are covered? Now, in a nutshell, every group, including a law firm, will decide if you are covered or not.
We decide who is covered. All companies decide who is covered. Well, this is a good point, right? I mean, somebody's got to decide this. I think that it's important how we decide. That's kind of an important point, right? I mean, well, first off, when we decide whether we are going to handle something as a self-defense related legal matter, right? Because we have two different parts to the Attorneys on Retainer. There's the self-defense related legal matter, and then there's the non-self-defense legal matter. So the issue is, how do we determine whether something is a self-defense related legal matter? Well, first off, we don't have any problems if it's actually a criminal act, right? Because unlike the USCCA, we don't have exclusions in our program for criminal acts or intentional acts. Not a problem with us. It's definitely a problem with them, as I've noted on many occasions. In fact, I did a whole video on USCCA critiquing their program, I think very fairly. And in that video, people can see I used the very contract that USCCA puts out. They exclude criminal acts. They say no coverage for criminal acts. So that's the first thing we decide, right? And of course, they made this decision for the Kayla Giles case, right? They decided in that case, after spending $50,000 on a criminal defense lawyer for their covered member, Kayla Giles, who, by the way, you and I spoke to.
We personally spoke to him.
Yeah.
Seemed like a very good, very competent self-defense, criminal defense attorney. He had done many cases along these lines. And he told us that as they were trying to disclaim her liability, he was actively telling the insurance company, I think this is a great case of self-defense. And in fact, I even got the jury instruction. I'm able to actually argue this in front of the jury. And she's presumed innocent. What do you mean you're disclaiming liability? So this is not us speculating. We actually spoke to the attorney.
That's right. And, look, people disagree. She ultimately got convicted, I think, with a public defender. And again, we're not taking a position on the actual facts, right? We didn't review the case. All we can say here is that the lawyer that USCCA spent $50,000 on to represent their member, Kayla Giles, decided himself this was a good self-defense case, and then they dropped her.
Yeah, that's right.
That was one. Then they made another decision on the Alan Coley case.
This is another defense attorney who we spoke to.
Yeah, and he didn't know why USCCA didn't cover Alan Coley. I don't know either, right? It could have been multiple reasons. I mean, maybe, and again, we're speculating here, maybe they decided it's a criminal act.
Right.
Sure didn't look good, but I got to admit, when I first saw that video with the prankster in Virginia, they also could have decided, well, maybe it's an act of self-defense, but, it happened at a mall. And at a mall, guns are banned. And there are lots of exclusions like that. I mean, I brought the list of things that we do not exclude, right? Criminal acts, negligent discharge, presence of alcohol or drugs, illegal weapon or no weapon or different kind of weapon. None of this is a problem for AOR.
Domestic violence-related offenses.
Domestic violence, places where firearms are prohibited, absence of a CCW permit, or you're a prohibited possessor. None of those are things. So
we don't care about any of those things. We will represent you.
That's
no
right.
problem.
So while it's true that we decide, how we decide is not the same criteria that USCCA uses to decide whether they're going to cover a member. And we don't have any history of failing to cover our members, especially in cases like Alan Coley, where, the public defender took that case to trial and got a not guilty on self-defense. Man, that's got to hurt for USCCA.
And Mr. Grieve describes those exclusions in his videos as, quote, small exclusions. You can nitpick over these exclusions. And while annoying, we have to have them in our contract. While annoying, okay, do you think that somebody who is now facing major felony charges, who's just been excluded for one of that laundry list of reasons, feels annoyed? Is that the proper adjective we're going to use here? Probably they feel like they're screwed. Probably they feel scared. Probably they feel like they were just dropped when they needed it the most.
Yeah, I mean, if it's not a big deal and it doesn't come up very often, why do you have it in your contract? I think that doesn't make any sense. He also said that he tried to call me personally. Wow, this is really weird. I must be the easiest lawyer on the planet to get a hold of. I mean, lots of people in the AOR program or considering the AOR program have emailed me personally. I think I put my email out in almost every video.
It's on the website, too.
It's on the website. You could call the firm, Attorneys for Freedom, and say, I'd like to talk to Marc in case Tom's still trying to get a hold of me. Tom, if you would like to get a hold of me, by all means, reach out. I'm happy to chat with you anytime. There are several different ways to get a hold of me. You could simply send me an email, Marc, M-A-R-C, at attorneysforfreedom.com. Alternatively, you could simply call the Attorneys for Freedom law firm. We're pretty easy to find, attorneysforfreedom.com. And when the front desk answers the phone, just say, I'd like to talk to Marc.
Come do a podcast with us, man. We can hash all this out in real time. We could do it live.
Yeah,
we
man.
Do it completely live and unedited. That's my preference, frankly.
Anybody who says I'm trying to get a hold of Marc Victor and just wasn't able to get a hold of him.
Not something I hear a lot.
No, it doesn't happen. Also, I know that I spoke with our AOR intake team, and they checked their records on the day that Tom Grieve said that he called and identified himself. We have no record of anybody by that name. Now, it could be a mistake. I'm not calling the guy a liar. He says he called. We just don't have any record of that. But all that notwithstanding, happy to talk to him or any other member of USCCA or any other program or anyone else for that matter.
Well, to his credit, he factually stated that he called our, quote, very helpful, friendly staff, end quote.
Fair enough.
We agree. We
Yes.
hire for character here at this law firm.
Fair enough.
Let's
Okay,
move on
so
to the next point.
Point one, it's true we decide who's covered, but we use very different criteria.
Not limited by a mountain slide of exclusions.
That's right. Point two,
What are you covered for?
man, this one's got to hurt. This
he
almost
didn't-
feel bad for the guy on this
Listen,
one.
okay. He didn't see that we added misdemeanors, increased our bond, added appeals, all that stuff. Okay.
Made a big deal out of the fact that we don't cover misdemeanors, which
In
used
his
to be
defense,
true.
let's not jump down his throat
Yeah.
just yet, because in his defense, I think he said at the end of the video that he was updating the video on December 1st. So obviously, this is a video he's had in the can for a while. It's the middle of December right now, so he's had it in the can for a few weeks. And I saw some comments on his video that says, "Oh, I think AOR probably got wind of this video maybe the day before and released it." No, we didn't get insider information. We updated our program. It's just unfortunately, Mr. Grieve didn't check before releasing this video. But he didn't see our updates, and he unfortunately released it. So let's not bash him too much.
Almost feel bad for the guy here.
Yeah.
Because this would have been a valid critique, and we've said it many times during that time period where we were not covering misdemeanors. And, hey, we don't cover misdemeanors. If you want misdemeanors, go with another program. But it's true we have updated our program. We do cover misdemeanors, so I think that's probably not a legitimate ding on the Attorneys on Retainer program.
Yeah, but just so people can understand a few things first and foremost, that's nice that in the stats that he gave and in his jurisdiction in Wisconsin, the vast majority of gun-related crimes are misdemeanors, but that is not the case with the majority of jurisdictions in the United States. Here in Arizona, for example, which is a very gun-friendly state, even referencing your firearm or pulling out in a defensive display that a prosecutor says is wrong, you're going to be charged with a felony called disorderly conduct with a firearm.
That's right. There are very few gun-related misdemeanors here in the very gun-friendly state of Arizona, so I'm not sure I agree with that. But in any event, it's kind of a moot point.
I'm proud that we're able to offer misdemeanors now. I mean, just kind of to get a little bit of the economic breakdown of that. Whenever you're an entrepreneur and you're starting up something new, and this Attorneys on Retainer program is something new. To our knowledge, we are the only law firm, legitimate law firm, not insurance-backed, legitimate law firm that is offering a national plan for self-defense coverage. Given that it's new, when you start something new and you're an entrepreneur, you don't have unlimited resources. And given the fact that there are lots of misdemeanor cases, we wanted to offer the services of our team, but we were having to limit it to just felonies because the misdemeanors would have been too numerous. Well, our product stood on its own merits, and people loved what it was about. And we listened to people and kept improving it, and now it's doing well enough, apparently enough to annoy USCCA and Tom Grieve, but it's doing well enough that we can afford to put misdemeanor coverage in there as well. It's a win-win. We're growing with our membership, and I love it.
Yeah, I thought it was interesting that Tom said all these exclusions, they don't really, quote, amount to a pile of beans or something like that. Well, then why have them, right? If they don't matter, why take them out? We don't have these exclusions. So if you're concerned about those exclusions, then AOR is a better choice. If you feel like Tom feels that any one of those things can exclude you from getting help from the company, then maybe USCCA is a better choice.
Yeah, I had an epiphany the other day while we were talking, Mark, about this exact point. I have a theory. I don't know if this is true, but I have a theory about why all these companies have all of these exclusions. So it's illegal to offer coverage, insurance coverage, for an illegal act. Okay, even Tom Grieve admits that in all of his videos, to his credit. But whenever you have somebody, let's take a look at some of these exclusions, these common exclusions. Being a prohibited possessor, being in a prohibited place with a firearm, owning an illegal firearm. Well, these are separate crimes than the crime you're going to be facing if a prosecutor says that you didn't act in legitimate self-defense. And so, as any criminal defense attorney knows, since they're separate crimes, they're going to appear in the same case on the same indictment or criminal complaint. Take a look at Alan Coley, who had not only aggravated assault, which was the prosecutor saying he failed at self-defense, it was imperfect in this matter, and having the weapon in a place that he couldn't do it, discharging in a mall or something like that. Well, these insurance-backed companies know it's illegal to cover illegal acts. They can't cover crimes, right? And so could they have even if they believed that Adam Coley acted in legitimate self-defense, could they have even taken that case?
Yeah.
Because now it's insurance covering an illegal act. Guess what? No problem with a law firm.
Yeah,
I'm glad we don't have to tiptoe around that point.
It's a very good point.
All right, let's move on to the next point.
Who is your criminal attorney?
Okay, I thought this was a fair point, frankly. If you sign up in the Attorneys on Retainer program, you know exactly who your lawyers are. you're getting our law firm. You're getting the Attorneys for Freedom law firm. You can find out about our team. Go to attorneysforfreedom.com. You can check out our 5-star reviews. Our law firm has been around since 1997. I've been practicing 30 years, a criminal defense lawyer the entire time.
You didn't dabble in prosecution, Mark?
I have never prosecuted anybody. That's not the mindset that I have. I like to fight the government. But it's true. If you don't want us, then don't sign up in Attorneys on Retainer and pick another lawyer. There are other good lawyers out there. But that doesn't really end the discussion, right? Because he kind of made it sound like you can have whoever you want with the USCCA. Remember that?
He used the restaurant
analogy. Unfortunately, it doesn't quite work that way. I noticed there was this quick, no unreasonable request is denied. Well, if you check out page 2, section D of the USCCA contract, and I go over this in my critique of the USCCA.
Check out the link down below.
It's pretty clear they get in their sole discretion to assign the counsel of their choice. Now, they do say they won't unreasonably withhold, but at the end of the day, you don't get to decide, they get to decide. And so maybe that works out great for you, maybe it doesn't, I don't know. But if you want to decide in advance and know who your lawyer is in advance, so say, for example, you call our 24/7, 365 emergency hotline. You got an incident and you need to speak to your lawyer right now. I think you're going to be SOL with USCCA.
That's right.
Because you might get to pick your lawyer. Who knows how long it's going to take? And if you don't know a lawyer, how are you going to decide who the best lawyer is? You're not going to be talking to someone who's going to be representing you right then and there to give you advice that they're going to own and be responsible for later on when they're representing you on that case.
This part is so important and has been the reason so many people have switched to our program. They want to have an existing relationship with a lawyer that they know that they can get a hold of instead of calling an insurance-backed company and they say, okay, we'll work on it, we'll get a lawyer, we'll figure something out, blah, blah, blah. They want to talk to a lawyer in that moment when an incident happens, and so that's a major advantage of our program. But I have to be honest, Mark, when he was talking about the restaurant analogy and everything like that, I just kept thinking of it in terms of their laundry list of exclusions, and I kept thinking USCCA is kind of like a restaurant where if you go in and the waitress sits you down, if you sit in the wrong chair or use the wrong fork or maybe you ordered the wrong drink, sorry, get out of the restaurant, no food for you.
Yeah, I mean, it's interesting, and there's always things you can say, right? I mean, yeah, okay, there are some advantages for having a local attorney, right? And I admit this. We've done many, many cases in other states. We have pending cases right now in other states. And so there can be some advantages, right? What's this judge about? Are there any special little nuances about the local rules? Well, look, for us to be admitted in another state, we have to have a local attorney on board. So it's not like we have absolutely nobody from the local community. Indeed, in the many occasions where we have selected a local counsel, which we need to be admitted pro hoc vice, of course, we pay that fee. If you're a member of the Attorneys on Retainer program, you're a client of our firm, we handle that. We do our best to try to find what I like to call a real criminal defense lawyer, somebody who is in the trenches, who knows how to represent people, has got experience doing this kind of stuff, and they got to be pro-Second Amendment. They got to be pro-freedom, and that's the kind of lawyer who can contribute to our team. So you will have a local attorney on board, and with our new questionnaire that's going to be in our client portal soon, one of the questions on that questionnaire is going to be, do you have a preference for a local attorney?
That's right.
If you do, then you put that on the form. That'll be the first person we do our best to get on board. And I say do our best because they may not agree, right? I mean, they may be too busy or something. But if that person is willing to serve as pro hoc vice counsel, and almost always they are, this is free money for them, right?
Right.
Look, we're going to send you some money. File the motion that we've drafted to get us admitted. We'll be lead counsel. If we got questions about some local things, we'll ask you, and you can give us some guidance there.
So the person of their choosing is going to be on the legal team, essentially.
You get the best of both worlds, right? You still get the local attorney who you've chosen, and you get us to do the case. So I think
I
that's,
saw a lot of comments too, like, what if I don't know an attorney that I want to choose, or what's filet mignon and what's ribs and everything, to use this
very good
analogy.
point.
And yeah, that's a very good point. And most people don't have a criminal defense attorney in their back pocket. Now, Mark, he did mention something about a certain global peace movement that this law firm helped to found.
Yeah, I mean,
that
we
is
have it-
very near and dear to our hearts.
Right.
That we espouse every day, not only to our friends, family, and all over the internet, but in courtrooms, to prosecutors, in our representation of our clients. We proudly stand by these principles. What do you think of the things he had to say about your stances there, Mark?
Look, people can check this out for themselves, and I hope they do. I mean, many videos I see.
Maybe he just helped direct people to our website.
Fantastic.
liveandletlive.org.
Yeah, check out liveandletlive.org. We've said several things there. I think the position is very, very clear as to guns and Second Amendment. I mean, I've been talking about these issues for literally decades now. And to summarize our position, if you are a competent, responsible firearms owner, an adult firearms owner, and you don't pose a risk of harm to another person, i.e., you're not mentally ill, something like that, you're not a violent felon, you should be able to have whatever you want. I think that's pretty clear. And so I encourage people to settle this one for themselves. Go to liveandletlive.org. Check out exactly what we're saying there. I noticed he flashed it on the screen really fast and said something about gun control laws, red flag.
Yeah, you're apparently in favor of red flag laws and homeowners associations taking people's guns away.
Yeah, very scary. And you know, if you just a tiny scratch underneath the surface, what you'll find is exactly what we said there is private property owners can make any rules they want amongst themselves. And so just like if a private business says no firearms allowed, that is their right as a private property owner. And if a homeowners association wants to say, we've all agreed here, no firearms in our community, it's a freedom thing. They have every right to make that decision, just like a homeowners association could say, we've decided everybody who lives here must have a firearm, an AR-15 in their home, or whatever they want to say. Then that's the rule in that community. And if you don't have an AR-15, you can't live there. That's exactly what we're talking about with Live and Let Live, and your right as a competent, responsible adult to make any deal you want.
Listen, we're interested in a free society.
That's right.
At the end of the day, there are principles that drive our law firm. That's why we have so many people who are proud to be a part of this law firm. We're not just showing up to collect a paycheck. This isn't just a job or a hobby or a way to get a check at the end of the day. I'm here at this law firm because I love the principles that it stands for. Our employees are here. Our attorneys have to sign a pledge. They all need to be freedom activists to work at this law firm. And you know this if you've seen us in court before. We've stood in front of judges and told them the law is wrong in this area.
That's right.
It violates the rights of competent adults to own their own body, property, money, and time. And
Right
we
there,
are
brother.
not
Right there.
compromising on that at all.
Not backing down. In fact, you want to debate that point? Happy to set a debate with anybody, anytime, any place on any of these points. You find something at liveandletlive.org you disagree with, you want to debate it with me, bring it.
Are you saying that you proudly stand by you're dabbling in politics?
Yes.
Is what I think he called it.
Everything
word you said.
Yeah, in fact, maybe we can even put a link to the debate that I did. I think that would be really fun, or at least the greatest hits.
You were a third party candidate, so they kind of shafted you on the time. But damn, did you use your time well, my friend?
And I thought it was nice that he said "Live and Let Live" party. Okay, I mean, live and let live. I hope there's a Live and Let Live party someday. But
Something to aspire.
Anyways,
to.
very proud of everything I said and did there, and stand behind every word and every position I took.
Hell yeah, brother. Moving on.
Number 4, bail. Bail is important.
Next, very important subject here, Mark. Bile. That's right.
Bile.
As you'll see in
I feel bad for
1844 in the video in big, bold red letters, bile.
And that wasn't the only typo there. But look, I want to give him a break on
It's
that.
probably not him. It's probably
Yes, right. People make mistakes. Look, there is there are some things you can say here as well. We checked with our ethics counsel long before we did this, and there may be a couple of states that say, hey, look, you, the attorney himself or herself, cannot post the bond. Very few states. This is an open question in those states, in many of those cases, as long as it's not the primary purpose of the representation. And in our case, it doesn't drive any aspect of the representation. It's not going to make us feel like we can't be entirely unhindered from that to do our job in the best, most aggressive, zealous, professional way we can. So I don't expect that'll be a problem in any state. But people will know that we do say in our contract, if any aspect of our program is illegal in any state, because, it's hard to say so many of these states are anti-gun and they don't like these programs, then we can't offer it. If there's a workaround and we can find a workaround, we'll deal with that. But if it's absolutely prohibited by law, then we're stuck with it.
There's even ethics opinions out there that say that if the defendant's release is part of the strategy in the case, for example, it's part of the overarching strategy, then it's much more arguable that an attorney can post it because it's not seen as a conflict.
That's right.
So this is very common, right?
Okay.
Because all the time I tell clients, maybe who are initially arrested, I tell them, look, I want you out of custody, probably not as much as you want to be out of custody, but I selfishly, as your defense attorney, really want you out of custody. And there's lots of reasons for that other than just the comfort of the client. Like, for example, probably sometime down the line, we're going to be standing in front of a judge and making an argument. We might have a prosecutor across the way saying, Judge, this guy's a danger to the community. He's not a good candidate for probation. We need to send him to prison forever. And then I can immediately take the wind out of that argument, out of the prosecutor's sails by saying, Judge, I don't know what the prosecutor's talking about. My client's been out of custody for months, maybe even years as the case is pending with no problems, no violations whatsoever. How can the prosecutor possibly argue he's not a good candidate for release?
All right, so let's give him a small point on that. That's fine, no problem. I will point out, though, as Tom himself says in one of his videos, if you plead guilty or you're found guilty, all coverage ends.
Coverage stops in the event of a conviction.
At least we still will represent people in these cases where these exclusions apply. And then there's the other part of the video, right? I mean, it's not one of the four things, and it was right at the end. The recoupment provision. I know why they brought that up, because a lot of people are upset about that, right? And I know he poo-pooed it in the video by saying, well, we don't usually ask, and why is it in there? We don't ever use it. It's in there because it has to be in
That's
there.
right.
It's in there because
And he admits as much in the video.
Yeah, they were required to put it in there. And the reason they put it in there is because they mean it when they say all coverage ends. And they've now expended money on something they can't expend money on. So they have the right to say, hey, we need our money back because, oops, we spent money on something we thought was going to be a valid self-defense issue, but like in 95+% of the cases, somebody took a deal. So sorry, they pled guilty and all coverage ends. And now we got the right to recoup everything, including the money we spent on bail. Wouldn't that be fun for a defendant who's thinking about taking a plea? Imagine being a USCCA member and being covered by a USCCA paid attorney who they selected. And now you're going to take a plea, and you now have, in addition to the weight of making that decision to waive your right to a trial and take a plea, you got to think, is USCCA going to ask me for who knows how much money back that they spent on the lawyer, on the bond, on everything else? We have none of that.
Yeah, I mean, and simply put, just because Mr. Grieve isn't personally aware of the recoupment provision ever being exercised doesn't mean it has never been exercised. But the part about this section that kind of rubbed me the wrong way is that he used it to try to gain points for USCCA. He gets done telling you that they're required. He's spoken personally to the folks over at USCCA and asked them, well, why is that recoupment provision even in there? And they told him, because it has to be. We're required to put that in there. Yeah. And then he goes and says, and that's because USCCA is transparent and upfront about, this requirement in the law. Hold up, I thought you just told me that they're required by law to put it in there. I don't know how many extra points for transparency they get for including something that's legally required to include. So that part kind of annoyed me. And to prove that we can represent our clients, even if they are actually charged with a criminal act or even guilty of a criminal act, we have a second provision to our program that not only none of these insurance-based programs have, they can't legally have the second aspect of our program.
Yeah, I think people sometimes forget that that because we're a law firm, we offer virtually everything we do at the law firm. This is what we call the non-self-defense related legal matter. This is basically any other felony across the nation. I mean, people could be charged with aggravated DUI or some other particular crime, or they could be sued civilly for something completely unrelated to self-defense, like breach of contract or defamation or something else. None of these other programs got anything for you, but because you are a client of our firm, we give you a 35% discount. That also goes for tort cases. Those are personal injury matters. Look, if you are going to be a member of a program and a client of a law firm, you should have access to a lot more than just self-defense related matters. I know that's the primary reason for most people, but there's a whole suite of other things that we offer at the Attorneys for Freedom Law Firm for our attorneys on retainer clients.
Yeah, just to be clear, competent, law-abiding, responsible adults get in trouble unexpectedly every single day. And if you need any proof of that whatsoever, talk to any criminal defense attorney with a busy practice. You'll know that so many clients come into your office and say, Andy, I never thought I would be here talking to a criminal defense attorney. I've never had any problems in my life. It happens. We understand that, and we can offer a discount on that, even if it's not self-defense related.
Especially with all the crazy laws today, right? Someone wrote a book that said everybody's committing felonies or something like that. It's true. There are so many crimes on the books right now that you may have absolutely no idea that you are violating. Just take gun-related stuff, right? There are so many regulations. I don't even want to get into it. All the different things that ATF has for rules and regulations that you could be violating without even knowing. I mean, one example is the FRT trigger, right? This seems obvious that it's, and I think this is going to shake out in the right direction, by the way, but for a period of time, and right now it's still unresolved, people who bought these things were being visited by ATF agents and could easily have been charged with felonies for having a fully automatic firearm without the proper license and documentation. So, look, there are so many ways you can be charged with a felony offense or sued. Anybody can sue you at any time for anything.
Like a car accident or something like that.
Why not open it up for an entire suite of things our law firm offers? So anyways, there's another gigantic area of benefits. It's not free. You get 35% off our normal hourly rates. Okay, we can't do everything without additional charge, but you get what I call the friends and family rate. And so it's another huge benefit to AOR members who are now clients of our firm. But I do agree with what he said at the end, right? At the end of the day, I think we have mostly good people in this business. And look, people have to decide for themselves what they want to do. No company is a perfect fit for every person. They have 800,000 plus members. Okay, apparently more of those members have decided they like the attorneys on retainer than USCCA is comfortable with. And that's why we got so much attention from USCCA, and I'm super proud of that.
We must be doing something right,
We're
my
doing
friend.
something right.
And let's keep making the program better and how we've made it awesome so far, thanks to your guys' comments. We've added so many features to the program and improved it in so many ways, including the most recent updates. We now cover misdemeanors and appeals, and we've done a bond increase. And guess what? We reserve the right to make it even better, and we plan on doing that as it grows. So thank you guys so much for helping us make it all possible and getting us to the area where we are right now, and the sky's the limit with this thing. We are simply not interested, Mark, in making the second best product in this industry.
If you're going to do it right, go big. Maybe we'll have a fun video with Tom Grieve coming up. Maybe he'll reach out and talk to me, and we can have a video and talk it all out. That'd be fun.
Maybe even after bickering about, these disagreements that we have about our programs, we could actually talk about gun law and have a really good, interesting legal breakdown of a video, or maybe talk constitutional law. He seems like a good lawyer.
Yeah, it'd be fun to talk to him. So reach out anytime. Happy to chat with you.
All right, guys. Check out attorneysonretainer.us to learn all about our program and what it can do for you. If you want to learn more about our law firm, go to attorneysforfreedom.com. If you enjoyed this video, do not forget to like it and subscribe to the channel. Maybe share it with a friend. Comment down below if you think we got something wrong. We love talking to you guys in the comments. Until next time, my friends, this has been Attorney Andy Marcantel and Attorney Marc J. Victor.
Peace.